Hello, everybody. Welcome to our webinar on tricky distribution. This is Alexander Roth speaking from Taylor Wessing. We have currently seen that there are other participants that are expected to join, not yet in. So I'd kindly ask you to give us just another couple of minutes to wait until they have joined as well, and then we'll start right on from, say, 3 minutes after 12. All right, so having waited another couple of minutes, I think we can start. Welcome again. This is the webinar on tricky distribution from Taylor Wessing. I'm speaking Alexander Roth and Martin Rothermel. And I'd like to start maybe with a very short introduction on Taylor Wessing US especially, and who's going to be your speaker, Martin. And then we'll get right into the presentation. So the Taylor Wessing US office, for those of you who don't know, is a representative office. So that means we're not practicing US law, but we're helping our US clients with all their questions on international law. We have built this office basically following our client base. We have a lot of clients in the US. That's why we wanted to be close to them and close to their legal challenges. And that's why we built this office 4 years ago. It's a small office, and we help, as I said, with everything which relates to international legal questions. And if it relates to German or English law, we can resolve those problems in the client's same time zone. Here at the West Coast, we're based in Menlo Park. If these are larger projects, such as M&A transactions or other larger projects, we help coordinating the teams from the West Coast, sometimes also lead the project with respect to Europe or other jurisdictions. And of course, we also advise a lot on privacy laws and GDPR from here. I'm heading this office together with Chris Jeffrey, who's a UK partner and an expert in GDPR questions. And I, for myself, I'm a corporate attorney. I've been practicing law 10 years out of Germany, the Hamburg office, where I've been doing mergers and acquisitions and all sorts of other corporate transactions, including venture capital, joint ventures, private equity, but mainly cross-border mergers and acquisitions. And I'm one of the two moderators of this webinar, and the other one to whom I'm going to pass over in a minute is your speaker, Martin Rothermel. He's based in Munich, and he heads our German commercial and distribution and dispute practice in Germany. So his focus is really distribution and also purchasing and quality assurance, as well as product liability matters. In distribution, he has very special expertise, which encompasses especially e-commerce, and that is also one of the key topics we want to spotlight today. We're going to speak about newest restrictions under European law on e-commerce, and that includes limitations to possibilities of price fixing and new regulations on geoblocking, as well as other restrictions on internet sales. And I would kindly like to ask you if you have any questions on the presentation, which we're going through. Just place them in the chat room, and we will then include them in our presentation. So with that all said, Martin, please take the lead on the presentation.
Okay. Thank you, Alex, for the introduction. Thank you, everybody, for joining our webinar today. I hope that you can see the slides on your screen. And as Alex already mentioned, you can ask questions on the team chat, and I will do and give an answer later on during the presentation. The presentation today is about tricky distribution under European Union law. Why is it tricky? It's tricky because distribution over here in the European Union is like crossing a minefield. All those nice and used measures you take in your distribution agreements in order to channel the products, to channel the territories, to restrict probably some territories from the other, to restrict customers, to grant exclusivity, to have non-compete obligations, and all this content of typical distribution agreement is highly regulated under European Union law, and it's regulated by competition law, better to say by antitrust law. And as you can see in this presentation, it might be tricky, and even big companies might make mistakes, and they are not only making mistakes, they are fined for these, and this is what we want to explain you today in this presentation. So I hope that you can now see the content. We basically have 10 typical cases in 5 groups, and it's a little bit today for a civil lawyer like me. It's a little bit a new adventure because I'm trying to explain it to you. We are cases, we are case law, because we do have those cases over here in Europe that are more or less giving the direction what is allowed, what is not allowed. And we have cases on Guess, a major manufacturer of fashion from USA. We have cases with producers of computer products, with a perfume manufacturer, with a sports company, everybody knows of us, with some travel agencies. And in addition to that, I would like to introduce to you today the new geo-blocking regulation in the European Union. So let's start with the first one. The structure of the presentation repeats itself in every case. The first slide will show you what the decision was, and it will give you an understanding of what was the reason for the fine that was determined by the Commission or by the court. And as you can see here, I kind of copied and pasted the very first paragraph of the decision on gas. This decision is only 10 weeks old, so it's quite recent. And as you probably can see, we have 5 hardcore restrictions that were found in the distribution agreements that were used by gas all over the European Union and beyond that in the whole European economic area. And those 5 hardcore restrictions are more or less typical. You might find that the one or the other is familiar to you. The first one was that the distributor was not allowed to use brand names and trademarks for online search advertising. The next one is that he needed a specific authorization from gas before he was allowed to have online advertising. The third one was that the distributor was prevented from selling to end users located outside its own territory. The fourth one was the prohibition that the distributor was not allowed to sell to other authorized wholesalers and retailers within this distribution system. And finally, the fifth one was that the distributor was not allowed to determine its own sale prices in his own discretion. So 5 more or less typical restrictions that you can find in distribution systems. To be honest, for a European Union lawyer, for a distribution lawyer, it is kind of surprising that a major company like Gas did have these 5 typical hardcore restrictions in its distribution system, because the European Union framework, the legal framework, clearly says that such hardcore restrictions are not allowed. And in order to explain you that, I would like to outline a little bit the framework within the European Union on distribution, on competition, on antitrust. We do have this
and
general
by the way,
prohibition.
Martin, sorry,
Yeah.
Just a very brief note for the audience. We are happy to share this presentation with you, so you don't have, for everything that you see now, you don't have to take notes, because we're happy to send this afterwards. We can see who has participated, and unless you don't want that, we can send it over to you via email. So you don't have to take notes. Sorry for that, Martin.
No, that's fine.
Editorial note, okay.
That's fine. So we do have this general prohibition in this famous Article 101 of a framework which is called TFEU, which is an abbreviation for the Treaty on the Functioning of the European Union. This is the current name for something that was previously known as the Treaty of Rome. There were some changes in the numbering, and quite recently there was a change in this abbreviation. Now we have it in Article 101, and it's clearly saying that all agreements between undertakings which have as an object or as an effect the prevention, the restriction, or distortion of competition, and in particular that aim for directly or indirectly fix prices or limit or control markets or share markets are prohibited. So this is our general prohibition that's applicable to all agreements between undertakings that have effect on the European Union market. So you cannot circumvent that, for example, by choosing another law, because this European Union law is applicable mandatorily in case the European market is affected. And in addition to that, we have a number of so-called block exemptions in so-called block exemption regulations, because for some reason the EU Commission found that not each and every prohibition of competition might be harmful or might be harmful to the same extent as another restriction, and therefore in some cases and under some preconditions, some of these typical restrictions are exempted from this general prohibition. And in order to make it easier, there were these block exemptions that grouped several typical similar clauses together, and that provided that when their market share is below 30%, meaning the market share of the companies, and the agreement does not contain hardcore restraints, there is an exemption from this general prohibition of our famous Article 101. And as you can see here, these hardcore restraints that are mentioned in this block exemption are again price fixations and restrictions of territories and restrictions on end customers and restrictions of cross supplies and some specific restrictions on spare parts. And these hardcore restrictions mean or have as a consequence that there is no block exemption from this general prohibition. And as you might have already noticed, these 5 explicitly mentioned hardcore restraints are the same that were found in the gas distribution agreements. This is the reason why I said that it might have been surprising for one or the other European Union lawyer. In addition to this block exemption, we have some procedural rules, and it's a regulation called Number 1 of 2003, and this regulation provides on the procedure and also on the fine, and the maximum fine that can be determined is 10% of the total turnover of the group of companies having these restrictions in its or their agreements, which can be, that we see later on, which can be a lot. But there's no rule without an exemption, because the EU Commission had the idea that it might be good to reduce the fine in cases that a company is cooperative in a proceeding, and such reduction of the fine can amount to 50%, and it can amount to even 100%, meaning no fine for the company who acted as a whistleblower, meaning the company who notified the EU Commission that there is some restraint in the distribution system that might be prohibited. So as you can clearly understand, the idea behind that was to enable or to give an incentive for every party of such a system to notify the EU Commission, which allows the Commission to have an easier job in initiating or conducting proceedings. What happened here? In the gas case, there was a selective distribution system in 30 European Economic Area countries, meaning that all countries of the European Economic Area had the same agreement. By the way, there was no gas in Iceland. Still, there is no gas products in Iceland, so this is the only one from the 31 European Economic Area countries that was affected here. And they had like one kind of the system in 14 and a little bit different kind of the system in the 16 other countries. And they had quite a huge network, meaning that they had about 8,000 approved brick-and-mortar retailers. Brick-and-mortar means that they required a reseller, a retailer to have a shop, a real building with real windows, real sales people and everything, and not only an internet platform. And all those wholesalers had about the same gas template, so the company was very successful in rolling out the same templates to everybody. And these templates did include those restrictions that you saw at the beginning of this gas decision slide, those 5 hardcore restrictions. Why did the EU Commission start these proceedings? This is a very interesting question because it goes back to a kind of famous sector inquiry that was conducted by the EU Commission between 2015 and 2017. And in this huge e-commerce sector inquiry, the EU Commission examined the e-commerce sector on consumer products as well as on digital products. And they did send Q&A lists to literally all companies involved, all manufacturers, all retailers, and they did receive, for the consumer products, they did receive about 1,400 answers. 1,400 companies had answered the Q&A list from the EU Commission. And more than this, the EU Commission received about 2,600 distribution agreements on consumer products. So
amazing.
The gain of knowledge...
Amazing number.
Yeah, amazing number. And you must imagine, Alex, that when there were 1,400 answers and they did receive 2,600 distribution agreements, there must have been companies who sent binders of agreements to the EU Commission, because when there is a number of companies not sending any agreement, but nevertheless there were 2,600 agreements sent to the EU Commission, you can imagine that there must have been companies sending a big bunch of material to the EU Commission. This e-commerce sector inquiry was published in May 10, 2017. And for everybody who is interested in the e-commerce sector, I really recommend to read this because it's really opening your mind. You see a lot of figures, a lot of numbers, a lot of spreadsheets telling you almost everything you need to know about the structure of e-commerce in the European Union. And you can find all of this via Google or any other search engine by typing in e-commerce sector inquiry and probably the date. And they have published that in English and other languages. And it's really a big report. The full report is about 200 pages, again subdivided into the field of digital products and consumer products. And I did only read the consumer products part because this is my turf. And I was really kind of unable to put it away. I had to read it from the beginning until the end. It was really interesting. And what is also interesting and not surprising is that with this tremendous amount of knowledge within the EU Commission then started some proceedings in order to fine companies that crossed the line of what is legal and what is illegal. And one of those proceedings was the proceeding against Guess. Guess might have been surprised, probably at the beginning, but after a while, I think that Guess understood the issue, and you can find in this decision, and this decision also is published. You can find it again on the internet. The long form of the decision has 44 pages, and it's very well written and easy to understand. And you can read in this decision that Guess did not really defend. Guess at the beginning understood the issue and was very cooperative, and on top of that, gas itself explained how much fine it might accept. And gas also gave a lot of information to the EU Commission in order to make their life easier. And this was, as we can see later on, probably a good idea. The system was effective, and this is the calculation of the Commission, for 1,400 days, because they found out that it started in January, and the whole distribution system in all the 30 European Economic Area countries as a reaction to this proceeding. The EU Commission identified relevant sales, and you can see the numbers. It is the sales in the European Economic Area affected by this distribution system, and it was about 250 to 300 million euros. And the Commission took a base quote of 7%. Interestingly, the Commission is able to take about 55% of the sales in very severe cases, but here in vertical restraints they only took 7% and calculated it on a day-to-day rate, multiplied it with 1,400, and they came to a basic amount of 75 to 85 million euros. But since gas was cooperative, as I mentioned, it was reduced to 39.8 to 1, means almost 40 million euros. So this was the first case. This was the gas case. And you can see typical restraints, typical hardcore restrictions, no way out of that, and the fine was the more logical consequence. The next case I want to introduce to you is something that happened last year also. It is a case on price fixation. And you can see those 5 producers of electronic components: Asus, Denon and Marantz, Philips, Pioneer. And again, I tried to copy and paste the decision, and on top of it, I copied what the EU Commissioner, Mrs. Vestager, said about online commerce and how important it is for the European Union and the European Union competition. And also, it is said here that there was a resale price maintenance system restricting the ability of online retailers to set their own retail prices. And this led to this price fixation identification and to the fine of 111 million euros. And as you can see here, this was, if you take a closer look, it was a decision on 4 cases, and the 4 producers were fined differently between 63 million and 7 million euros. As I outlined the legal framework before and the way those decisions are taken, you might understand how it came to these different fines here. Again, there was a closer look on the territories, on the numbers, on the turnover, and in all cases, and this is important to know, the fines were reduced due to cooperation to, and here I made a typo, it's not by 60, it's to 60 or 50% of the fine. So again, we had very clear cases of illegal restrictions in the agreements, and the manufacturers, the producers, did understand that, were cooperative, and therefore the fine was lower than it could have been. Since this was a very easy case, I made it faster, or I explained it faster than the gas case before, and this takes us to the next one. The next one is the very famous
Martin, just
Coty.
one question, maybe also for the audience, interesting. How do these cases actually pop up then? I mean, I understand there was a sector inquiry, so that's one way. I guess another typical way is also if you have an M&A transaction, then all those agreements of the targets are reviewed and those clauses are picked up, and then obviously you try to renegotiate these prior to sign or close. But what are other ways? Is that an angry distributor or that tries to be a whistleblower, or how does it actually pop up?
Well, here in this cases, there was obviously no whistleblower, because otherwise we would have had one participant without any fine. So most likely there is a unsatisfied part of the distribution agreement who is angry for whatever reason and notifies the commission, or it is some competitor who learns about the reason why the other competitor always have the same price everywhere. These are the most likely reasons for these proceedings.
Mm-hmm.
And in this very famous Coty case in December 2017, the topic was about platforms. Platforms like eBay, platforms like Amazon. I mean, you do know that there are these wonderful platforms where you can easily find a lot of products from a lot of manufacturers or resellers, and you can compare the prices, basically the prices, and you can choose the cheapest one and make the best bargain. And retailers have an interest to market the products on those platforms, because then the customers might find this reseller easier than searching for the reseller's own website, platform, or whatever. So those platforms are successful for very obvious reasons. And there was, and you can see that in the next slide, and I'm going to explain it a little bit later on, there was a lot of discussion starting in Germany whether or not it was allowed, or it is allowed, for a producer or manufacturer of products to prevent its retailer from using these platforms. And since there were a number of different decisions over here in Germany, one court did ask the European Court of Justice how the European regulation on competition and antitrust has to be interpreted and has to be understood with effect to these platforms. And there were three major findings of the European Court of Justice, and I again copied that and pasted it here. And the first one is that a selective distribution system itself complies with Article 101, meaning that it is not prohibited when these criteria for the selection of the distributors based on qualitative aspects and are applied uniformly and non-discriminatory. This is the first finding. The second one is that it is not illegal to prohibit an authorized distributor from using a platform. And this was like an earthquake over here in the European Union, because some courts decided that you cannot prevent a distributor from using a platform. But here, the European Court of Justice said that it is possible to do that, especially in case of luxury images and selective distribution systems. And in addition to that, and this is what you can see in number 3 here, this is not a hardcore restriction of customers under this vertical agreements block exemption that I explained previously. So this very important decision over here in the European Union was based, like I mentioned before, on some other decisions already from the European Court of Justice, some old decisions. The Metro case is from 1976, and there are other perfume cases a little bit later on, and they all more or less decided similarly, except of this Pierre Fabre decision, and there was a need for the European Court of Justice to put the findings in the Pierre Fabre decision in line with this other decision, and this was done in this Coty decision. Therefore, the Coty decision is very famous over here in the European Union. As I mentioned, it started in Germany, in Frankfurt, 2 decisions in Frankfurt, regional court, and then confirmed by the higher regional court. And we had other similar case law even since 2007 on Scout, which is a backpack company, Casio, which is an electronic manufacturer, and Deuter, again, a backpacker company that's producing backpacks. And since these decisions were different, there was a need that the European Court of Justice found clarity, and this is what he did. The next case is not about another platform. It's about search engines. I don't know how it is in US or in UK. I do know how it is in UK, of course, but I do not know how it is in US. But in European Union, you can find a lot of search engine platforms, and those platforms work like an online platform, work like eBay and like Amazon, with one big difference to that, because you cannot make your purchase on the search engine, but the search engine does link or guide you back to the platform or the website of the retailer. And this is the difference in the cases. And for some reason, the German Federal Court of Justice decided that it is not allowed to prohibit a retailer in using such an online search engine. And this is, again, copied and pasted here what the German Federal Court of Justice determined. It says that, first of all, Essex had a system where the retailer was prevented from using such a price search engine, and this is what I printed in bold letters, the German Federal Court of Justice confirmed the decision of the German Cartel Office, we call it Bundeskartellamt, and the Bundeskartellamt decided some years before the German Court of Justice that Essex was restricting in a hardcore restriction the retailer by prohibiting that he is using these search engines. So it's important to understand that these platforms are treated differently than the search engines. You can prevent your distributor from using a platform, but you cannot prevent him from using a price search engine. And why is it? You can find the reason for that again in the e-commerce sector inquiry. As you can see, a lot of recent developments goes back to that sector inquiry. And in this report of this sector inquiry, you find that the EU Commission made a distinction between a search engine and an online platform based on the simple fact that the platform allows a direct purchase, whereas the search engine is leading back to the website of the retailer, and this is the reason why those similar situations are treated differently. This is a nice picture I choose because when you read the decision on Essex by the Bundeskartellamt, German Cartel Office, and it's again published, it's very long, it's about almost 100 pages, you can read that the Cartel Office gave Essex frequently the possibility to refrain from its system, but for some reason Essex was, I don't know if it's the correct word, was stubborn, insisted on its legal appraisal, and therefore was decided that it is illegal and that Essex had to change its distribution system with respect to these search engines. So the cartel office tried to reach out at the hand to the manufacturer, but for some reason the manufacturer did not take it. The next case is a nice one because it's about holiday. You know probably those holiday booking platforms like Booking.com or Expedia.com, or in Germany at least very famous, it's HRS, Hotel Reservation Service. And you should read this slide from the bottom to the top, because the first decision was in 2015, and it was preventing HRS from prohibiting the hotel to grant cheaper prices than the loan, or if you are calling the hotel, then they grant on the platform. And the reason for that is that these best price clauses, so to say, or most favored nation clauses, or in Germany we say English clause, they were not exempted from this general prohibition because the market share of HRS was higher than 30%, and the same was the market share of Booking. The only company who came away or went away with it was Expedia, because the court in Cologne decided that Expedia has not a market share of more than 30%, and therefore this kind of prohibition was exempted by this vertical agreement's block exemption. To be honest, I always tried to call a hotel directly. I, of course, did choose the hotel from these booking platforms, and then I tried to get a cheaper price by calling the hotel directly. Before these decisions, in the time where those decisions were met, and even now. But for some reason, I do not know how your experiences are. There is no practical impact. In very, very few cases, at least me, myself, and I, we find that the hotel is granting cheaper prices when I'm calling directly and not making my reservation over this reservation platform. So, for some reason, reality bites theory. The impact might be very small, but nevertheless, we now do know that these best price clauses from HRS and Booking are illegal. And what is
so? Are you saying, Martin, that basically, even though if the clauses vanish from the agreements, they still have then oral agreements, and of course the hotels they want to stay within the network and on the platform, and that's why they behave like that? Is that what's happening in the back? What do you think?
I do not know the reason. To be honest, I do not know the reason. I have two theories. The first theory is that the people that are picking up the phone are not allowed to make kind of deals or price discussions with me at all. If you are calling a major chain, you have somebody at this desk, and this person is offering the prices of the booking system, and if you ask for a cheaper price, even if you stay 5 weeks, they have differences in deciding on that. This is the first one. And the second one is exactly what you suspected. It might be the case, or it might be the case that the hotel found that the system has benefits, and sticking with the system, even if it's not in the agreement, might have benefits for the hotel. So we probably do not know the real reason. But interestingly, one of those very famous European holiday countries like Italy, Austria, and Switzerland, which is of course not within the European Union, but probably close, at least from Munich, where I am, they have laws. They issued laws some years ago that these clauses were illegal in order to protect the hotel industry of the country. But even there, my very personal experience is not telling me something different than what I outlined before. So, we are now done with the decisions, and the last topic I want to explain is this brand new geoblocking regulation. It became effective in February or March last year. No, not true. It was published in February or March, but it came into effect on December 3 last year, and it basically says that you are not allowed to sort the people that are visiting your website by the fact of their home address. So some websites, and you might have experienced this personally, are routing the customers when the website found about the IP address or some other reasons where the customer comes from, then it's probably routed to another website of the same company from another country in order to enable different prices, different offers, different conditions to different customers from different places. People told me that those websites are smart enough to identify whether or not I am from Munich, which might have better wages than some other countries in Germany, and therefore I probably get a higher price on the website as if I would visit the website from a country in the eastern part of Germany, for example. And some people told me, and this was really frightening, some people told me that the websites were so smart that they know if I am visiting the website from an Apple MacBook or from a Microsoft machine, because the website or the people behind it understand or have a suspect that when I'm using Apple, I might have deeper pockets than if I use some Microsoft machine. And this is really frightening. And this is now not possible anymore, at least in theory. This regulation basically has 3 relevant articles, and they say that people must be treated equally. All people must have the chance to get the products from everywhere. Also, the retailer is not forced to deliver everywhere. And people must get the same conditions. And this is really interesting. And also interesting is that there is a fine up to 300,000 euros for one single case of non-compliance. And I thought that now a lot will change. But I found out that I did not experience a lot of change. I did not experience that websites changed substantially, and I think that the industry has not yet really taken notice of this regulation, and probably we can see some other decisions. In this case, it would be a authority in Germany called the Bundesnetzagentur, which would probably try to enforce this regulation over here in the European Union and Germany. But this is basically what I wanted to tell you.
And Martin, you mentioned, just a quick question on this one, you mentioned the sorting by geography, that's one thing. You also mentioned the sorting by quality of customer, for example, using MacBook or other computer. Is both then prohibited, or is the prohibition limited to geo sorting? Is it because that makes a big difference, because websites are extremely smart. You said that, and I've recently talked to a founder of a fintech company, and that was absolutely amazing. They're using technology to track the speed by which the user is actually filling in the credit application form, and if it's too slow, they will not grant the credit because they assume this person is not it's not going to be a good consumer because it's not very smart, and will likely default. And if it's too fast, they're going to assume it's going to be a fraud because they're so fast and an unnaturally way fast that there's a computer that they think. Amazing, but would then I mean, this kind of qualifying your customer, does that fall under the geo-blocking regulation then, or is that something different? I would think it's different, but
yeah, the question is excellent, and you already gave the answer, and it's by the name, it's geo-blocking. So I do not understand the regulation that it is intending to make Apple and Microsoft users treated the same way, or fast or slow template completion is the same way. It's only about geography.
Okay. Good. Well, then I think we have come to an end of the presentation. If you have any questions, feel free to shoot them now. Use the online Q&A tool that you should be able to find. And if you don't have any questions, then I would thank you very much for taking the time today to dial in. And thank you, Martin, especially. I realize in Germany it's getting quite late now, so thanks for making this possible at a late evening in Germany and giving us this interesting update on European case law on e-commerce distribution. And with that said, and still not seeing any questions popping up here, I think we can also conclude the session, and hopefully, we will be in touch at the next webinar. And if you have any feedback or criticism that you would like to share, please feel free to just shoot us an email. You can also use the Q&A tool and let us know what you liked, what you didn't like, and we're happy to learn from that. Now I see a question coming in from a person asking, can you give us a link to the geo-blocking regulation? Of course. What we're going to do is we're going to send you an email with the presentation, and it's going to include a link to the geo-blocking regulation as well as a link to the e-commerce inquiry, the sector inquiry that Martin has referred to. I'm not sure if you guys are going to be so enthusiastic that you're going to read it all as Martin did, at least on the product side, but maybe you are, and hopefully you enjoy the read. And again, thanks much for dialing in, and hope to be in touch at our next webinar.
Okay. Great.
All right. Thanks everyone, and bye-bye.